order of the day number 3.
Interrupted debate on the first reading of the taxation bright line test for residential land bill.
On the last occasion, the House was considering this bill. The Honourable Hekia Parata was speaking on behalf of the Minister and has 9 minutes 30 seconds remaining to speak. A point of order, Grant Roberts.
Mr Speaker, I see that, and I know as in the context of this point of order, I hope you'll allow me to do this, I see that the Minister who began the speech is not in the House, and I draw your attention to Standing Order 287, which says that the member moving a bill's first reading must, on the commencement of that member's speech, nominate the Select Committee to consider the bill and then talk about any special powers or instructions that are required. As I recall, I was in the House when the Minister was about to do that and was in, I suspect, in the middle of the referral motion. It was certainly one of those referral motions that had both a shortened time frame and also the request for the House to allow the committee to meet when the House was sitting and on Fridays and so on. And I just wonder, Mr Speaker, seek your guidance on what happens when that Minister, who is the person noted under Standing Order 287, is no longer here, whether or not that the Minister has to complete it, or can another Minister complete it. I'm unaware of whether this happens before, but it seems like a very unusual situation, particularly when the Minister, I'm not even sure had completed her introduction of the bill.
Tim McIndoe.
Thank you, Mr Speaker. I think the important thing to note here is that the question hasn't yet been proposed. It is true that the Honourable Hekia Parata did commence the speech on behalf of the Minister. McGee is very clear that a Minister must introduce a bill if he or she is responsible for it, unless he or she is unable to do so. That was certainly the case the last time this bill was being considered, but it had literally just commenced. The Minister in charge of the bill is now here. The question hasn't been proposed, and I submit, therefore, that the Minister in charge of the bill must be the person who continues to move this particular part of the first reading.
Grant Robertson.
And I understand the point that the member's making, but I think he slightly missed the point I was making, which was that it's not a matter of who was or wasn't here at the time. Minister Parata began this bill. She moved what is specifically required under Standing Order 287. And that's my concern, is that I'm not sure that we've had even completed that. We're now going to have a different Minister stand up, and I think we could be outside of Standing Order 287. And, Mr Speaker, I'd perhaps invite you to consider a ruling on this matter. I'm not sure if it's been considered before, but clearly we have a specific standing order that requires the member moving the bill. That member was Minister Parata, who is no longer here.
Is there any further comment? Right, well, I'm sort of slightly lucky in that I was aware of the fact that this possibility would occur. And if members will sort of stay with me for a short time. Well, the member, if she interrupts again, will have no choice but not to. Ministers are generally entitled to act in the House on behalf of absent ministers. It's long established in McGee 175 and also in Erskine May, so it's a tradition in Westminster Parliaments. In this instance, a minister moved the first reading of the bill on behalf of the minister in charge of the bill, and that speech was interrupted. The same event arose in the House previously in 2007. There was a minister who moved the third reading of a bill on behalf of the minister in charge of the bill. Debate was interrupted, and when it resumed, in fact, a third minister continued the speech. It was the Weathertight Homes Resolution Services Remedies Bill. Whether members might like to think about the successfulness of it, but we'll leave that. Volume, and people see Hansard, volume 641, pages 11251 and 11298. However, this event went unchallenged. Other than giving the call to the minister, there was no speaker's rulings on it. So I think the first point that has to be ruled on is whether the minister acting for the minister had in fact started her speech, and Mr Robertson was marginally incorrect in that she had completed the paragraph with regard to the reference to the Select Committee and the restrictions. That's all she'd done, so she'd moved the bill and indicated the committee and the conditions with regard to report back and speaking times that the minister in fact was recommending to the House. And if one does look at 287, it is very clear that the minister had started her speech because it says that the member moving the bill's first reading must on the commencement of that member's speech. So as to the question as to whether the speech had started, yes, it had started. The next ruling which is necessary is whether a minister can complete a speech that has been started by another. It is not a matter which is referred to in standing orders or in Speaker's rulings or in McGee, or according to the relatively quick research that I've done in Erskine May. Strictly speaking, the minister completing the speech is not necessary. The required moving and the conditions have in fact been put before the House. The minister who started the speech could complete it, but that would require the ridiculous situation of the minister in charge of the bill having to leave the House. Another option available to the government, and a more likely one, would be for the government to abandon this speech or the rest of this call and the minister to take a speech later in the debate. A minister's speech in moving a first reading is something which is very important. Speakers have traditionally treated such matters as reading speeches leniently because it is a matter of getting things onto the record of the Hansard on behalf of the government, probably more so than any other speech. There's also the question of what is before the House now. The question has not yet been stated, as Mr McIndoe had pointed out, and that occurs at the end of the speech. So the question of whether a minister can complete a speech started by another minister is one which I think should be considered by the Standing Orders Committee. I think it is something which we at least need a Speaker's ruling on, and possibly some clarity with McGee and or standing orders. But in the interim, I'm not prepared to rule the minister cannot act for each other in this way, and therefore if the minister effectively act for himself in completing the speech started on his behalf by another minister. Roger McLean.
Mr Speaker.
Oh, Todd McLean, one of them.
Mr Speaker, thank you, and I thank you for the compliment. Can I also thank you for your ruling and agree that it's something that needs to be looked at in greater detail, and thank all members.
But the member won't refer to it.
We do thank all members for their understanding of this. So, Mr Speaker, continuing with the speech on this important issue, the government is committed to ensuring fairness in the tax system and making sure that everyone pays their fair share of tax. This bill continues that focus. Its objective is to improve compliance with the current tax rules for land sales. The current land sales rules can be difficult to enforce, particularly when they are based on a person's intent. In this case, for the gains made from the sale to be taxable, Inland Revenue has to be able to determine that a person bought a property with the express intention of selling it for a profit or property speculation. Inland Revenue applies its current intention test, which makes gains from the sale of land purchases with a purpose of intention of disposable taxable. That test stands, Mr Speaker. The government is not proposing any changes to that. What this bill proposes is a simple but effective measure for the buttressing of that test. The Bright Line test will require income tax to be paid on any gain from the disposal of residential property that is acquired and disposed of within 2 years, subject to some limited exceptions. The proposed Bright Line test applies only to the disposal of residential land. It does not apply to land used predominantly as business premises or farmland. Residential land is defined as land that has a dwelling on it, land for which the owner has an arrangement to erect a dwelling, or land that, because of its area and nature, is capable of having a dwelling erected on it. The Bright Line test will apply to gains from residential property that is acquired on or after the 1st of October 2015 and disposed of within 2 years. The 2-year period for the Bright Line test runs from the date of the acquisition of the land to the date of disposal. The date of acquisition of is the latest date on which the person acquires an estate or interest in that land. Generally, this will be the date that the title is registered for the purchase of that property. An additional rule applies for off-the-plan sales. The date of disposal is generally the date that a person enters into an agreement to sell the property. When the disposal is other than by sale, for example by a gift, the date of disposal will be determined by current tax rules. The objective of the bill is to target people who seek to make a profit from property speculation. There are, therefore, 3 specific exemptions to the Bright Line test. These are for the disposal or transfer of property that is the main home of the owner, inherited property, and property under a relationship agreement. Mr. Speaker, a property will be the main home of the owner when it has been mainly used for most of the time that the person has owned that property as their residence. Where a person has 2 or more homes, their main home is the property with which the person has the greatest connection. If the property is owned in a trust, the main home exemption applies when the dwelling is the main home of a beneficiary of the trust, subject to limitations. A person cannot use the main home exclusion if they have already used the exclusion twice in the previous 2 years. Members may recall that this Bright Line proposal was announced as part of a suite of proposals to improve property tax compliance in this year's budget, along with the requirement that a New Zealand IRD number is required as part of the land transfer. Offshore persons will need a New Zealand bank account before they can get an ID number in order to buy a property, and that non-resident buyers and sellers must also provide their foreign equivalent of an ID number from their home country. Together, these measures and the proposed Bright Line test introduced by this bill will help improve tax compliance with the tax rules for land sales. Mr. Speaker, it is with pleasure that I commend this bill to the House.